Let me record. Okay, sorry. Without consideration, we cannot have a valid contract. So it is one of the key elements of every contract. Now, we have types of consideration. We have types of consideration, three main types of consideration. And we have what we call, with the types, we have what we call the executory consideration, we have the executed consideration, and then we have past consideration. You see that the executory consideration we say is a future consideration. The executed is a past consideration. And we also have another consideration called past consideration. So in most cases, students confuse the executed with past consideration. But this evening, we will make the difference between the two of them very clear. Now, to start with, let's look at what executory consideration means. Now, when we talk about executory consideration, we are simply referring to a future promise. You know, like I enter into a contract with the contract I entered into with Yvonne. The first scenario I gave, that Yvonne should wash my car for me and I will pay her 20 Ghana cedis. Now, the consideration is in the future. Yvonne should wash my car for me. So if Yvonne washes, I want Yvonne to wash my car for me before I will give her that promise I made to her. So this consideration, which will move from Yvonne to me, that is when Yvonne washes my car, that is called executory consideration. Executory consideration. So where we have the consideration in the agreement being in the future, then we term it as executory consideration, because I expect Yvonne to wash my car for me before I give her the 20 Ghana cedis. So the washing of the car, which Yvonne must do to obtain the 20 Ghana cedis, is the consideration that Yvonne is supposed to give me. But that is not something that Yvonne has already given or is in the process of giving. But Yvonne will give at the right time. And we call consideration in the future executory consideration. And then we have what we call the executed consideration. Executed. Now, executed happens to be past consideration. And what we mean by past consideration here is that, for instance, with the same scenario I gave, for Yvonne to wash my car for me, and I'll pay her 20 Ghana cedis. Let's say I told Yvonne to wash my car for me tomorrow morning, and I'll pay her 20 Ghana cedis. Now, tomorrow morning, if Yvonne washes my car for me, tomorrow morning, if she washes my car for me, then it means that the consideration has now moved from future to past. Now, Yvonne has already finished washing the car. So the consideration here is in the past. That's why we call it the executed consideration. The executed consideration. Now, so I hope you understand the executed and the executory. Now we move on to the past consideration. Past consideration. With past consideration, here there is no promise to do something for the other party. What happens is that the promise or the consideration comes after a particular act has been performed. Let me use a scenario to illustrate what I mean. For instance, I happen to be driving my car, and then I saw you standing by the roadside. Let's say it was a very hot day. The sun was very scorchy, so you were standing by the roadside sweating. And I happened to get to where you were, and then I offered to, let's say, drive you from maybe Tetekwashi to La Paz. Now, when you sat in the car, I played some nice tune. Apparently, the music I played happened to be your favorite song. So you were so excited to the extent that when we go to La Paz and you are lighted, you were very happy. So in your happiness, you told me, or you made a promise to me that, oh, don't worry, I'll give you 70 Ghana cedis to support your fuel. This time, what happened was that after I gave the lift to you and you were impressed by maybe the way I drive or the way I treated you in the car, blah, blah, blah. So you decided to give me a promise. And that promise is you pay for my fuel. You give me 70 Ghana cedis for my fuel. Now, the very moment you make this so-called promise, remember that this promise came after the act has been performed. And in law, we call that past consideration. Past consideration. Now, past consideration, normally, some people term it as no consideration because the act was not something that, when the parties were making the agreements, or when they were signing the contracts, there were, if they had maybe taken notice, or if they had incorporated a particular promise, or let's say when the two parties met, if they had agreed that if you give me a lift, I'll pay you 70 Ghana cedis, then that would have been an executory. But this one, the lift came before the promise came. And when that happens, it is no consideration. In law, we call that past consideration. Now, there are some exceptions though, because it is not in all cases that a promise that comes after an act has been done will be considered as a consideration. So we will look at 3 or 4 instances where, let's say 2 or so instances where there can be an exception to the previous, there can be an exception to past consideration. Now, the first point is what we call previous request. Previous request. If you happen to be doing business with, how do you call it? If you happen to be a businessman, and then you entered or you had an agreement with somebody some time ago, or let's say you requested for something some time ago, and then the thing delayed, it came at a time when you were almost, through with whatever you needed, the request, whatever you needed how do we call it? Let's say request, yeah. Now, once it is a business situation, and you had made, even let's put this business situation aside because that's the second point. Once you have made a previous request, when the person brings a item or deliver what you requested, you cannot, that will not be termed as a past consideration because it is a previous request you made that has delayed and maybe they are now delivering. So that whenever there's a previous request, you cannot term that as a past consideration. There's this case here that you can look at. Lampley versus Braithwaite. It's a very long, very old case. It's a very old case, 1615. Okay, I want you to go and, when after class or in your free time, try and get this case, the full details of the case. If you Google it, you'll get. And then read all the nitty-gritties of the case because it is from this case that some of the exceptions to the past consideration rule came. Now, I don't want to read the case. I want you to go and read. I want you to go and get the full and then read. But just for the class, let's just talk about it small. Now, a man killed or murdered somebody, and because of that, they caught him, and then they were about doing, he was due for hanging. Then he was able to convince his friend, who happens to be the claimant or the plaintiff in this case. He was able to convince his friend to ask ask for the king's pardon. That is so that he will not be hanged, but maybe be given a lesser punishment. So this guy was also highly connected. So he was able to convince the king to forget about what the man did, which was going to get him killed. Now, when this guy was, pressing the defendant to speak to the king on his behalf, he happened to have made a promise that if he's released, as in he becomes a free man, he will pay him £100 for his efforts. So when the matter went to court, the court had this opinion. The court held that whilst the promise to make payments came after the performance, and was past, after the performance, and thus it was past consideration, then we can, since the promise came before the consideration, you cannot term this as a past consideration because there was a promise which was made before the consideration even came. Now, the second area of exception is business law. Yeah, business. When you have a business situation, this is what I was talking about earlier, that when you have a business situation, every agreement that is entered into is presumed to be binding. If you remember from the intention to create legal relation. We said that in business situation, every agreement is expected to be binding on the parties. So in a business situation, when one party, makes a promise, the other party is also expected to abide by whatever terms and conditions of the business contract. And once this is in place, then once the promise came, then you cannot say that, oh, he and I, we are in terms where we cannot make this binding, blah, blah, blah. That cannot be the case, because in business situation, when you buy, you sell, you reap profit, and then you invest whatever you've made in the business. So whenever you enter into an agreement, which is supposed to be for business, we see that as not a past consideration. Then we have rules of consideration. Now, the first rule of consideration is what we call consideration must be sufficient, but need not be adequate. We are saying that the important thing here is for consideration to be sufficient. It is not the court's responsibility to investigate as to whether the consideration was okay for the parties, blah, blah, blah. So far as the consideration is seen to be adequate, then that is it. It qualifies. So it doesn't matter whether, in a contract agreement, the consideration value will not determine whether the case will be admitted or it will not be admitted in law. But so far as there's consideration, it is presumed to be adequate. So consideration must be sufficient, but need not be adequate. And then the second one is consideration must move from the promisee to the promisor. Of course, it didn't come, but then I'm sure you know by now. So we are saying that the consideration must move from promisee to promisor. Now, promisee happens to be the person making the promise. The person to whom the promise is being made, and the promisor happens to be the one making the proposal or making the agreement. Now, if we say that consideration must move from the promisee to the promisor, then we are saying that it is the promisee, the one to whom the promise has been made to, who actually who is supposed to give the consideration, which is the major important item in the agreement the two of them have undergone. So it is the consideration must move from the promisee to the promisor. Then the third one is what we call public duty, existing public duty. Now, whenever somebody has a duty to perform, the person cannot, the person cannot come out and expect maybe somebody to pay him for what he or she has done. So far as the particular, person is somebody who works with maybe any of the state-owned institutions or whatever. Now, so far as the person has an existing duty to perform, then it is somehow, safe. Then it becomes saved. Now, I think, okay. So whenever somebody has an existing public duty, that person cannot consider that existing public duty as a past consideration. Existing public duty is not a past consideration. So if someone is under public duty to perform a task, then agreeing to do that task is not sufficient. I mean, you cannot expect, let's say, a payment to be given to you for performing that public duty that is expected of you. That cannot be, I mean, it cannot amount to past consideration, because with the existing public duty, whether I mean, you like it or not, you have to do it. Whether you like it or not, you have to do it. So by agreeing to do it cannot attract a different payment, which you can even go and say it is past consideration. No, that is not the case. If you read the case of Collins versus Godfrey, what happened was that Godfrey promised to pay Collins if Collins would attend court and give evidence on his behalf. Meanwhile, the court had already subpoenaed Collins to come and give testimony. So when Collins went to give his testimony, and then Geoffrey, and then, yeah, when he went to give his testimony, he attacked Godfrey for the promise of £100. Okay, I think this one, the amount didn't come. He attacked Godfrey for the promise. And what Godfrey did was to, Godfrey came out to tell Collins that, no, I cannot pay you, because I won't pay you because what you did, you had a subpoena which would have by all means made you go and give your testimony. So in that case, we cannot classify an existing public duty as a past consideration. It cannot be the case. Okay. Okay. All right. So I think I was all right. My people, what we are doing falls under rules of consideration. I think I have been making reference to past consideration, which is not supposed to be the case. I told you I am an early sleeper. I'm dozing off, and that is affecting my lectures, I tell you. All right. Okay, what we are doing, and let me just go back. Let me go back. You have to forgive me and bear with me, okay? I've already told you my problem, that I am an early sleeper, so this time is not favoring me at all. So just brush it off and let me take it again, okay? Now, when we talk about consideration, I've already told you is an item of value given in exchange of a promise. Now, there are some rules that govern consideration. These rules determine whether a particular act amounts to consideration or a particular act can be accepted as a good consideration. So these rules are like what, in case, for instance, there's a problem, there's a breach of contract between two parties who entered into a contract and the matter happens to find its way in court. The courts normally use these rules as the benchmark to determine whether consideration in that particular contract was, to determine whether a particular act performed amounts to a consideration or is a good consideration or not. And I was saying that the first rule says that consideration must be sufficient. It need not be adequate, meaning that so far as the two parties have agreed that, for instance, I told Yvonne that wash my car for me. So Yvonne washing my car for me is a good consideration. You cannot say that, or later on, if Yvonne washes my car, I cannot come and tell Yvonne that, oh, you cry by washing my car alone is nothing. Pouring water alone on the car is nothing. Why should I pay you? Because car washing is nothing. Meaning that I'm trying to tell you that the consideration that Yvonne gave is not sufficient enough. It's not adequate enough. But the court will not look at a particular consideration's adequacy. All the courts will consider is, was it sufficient? If the answer is yes, then it is a good consideration. In this example that I told Yvonne to wash my car for me, I specifically requested that Yvonne washes my car for me. So if Yvonne washes my car for me, it is a sufficient consideration. I don't need Yvonne to perform a particular act that is so highly costly for me before I will say that, oh, this is a good consideration. No. The rule says that so far as the rule says that so far as the consideration is sufficient, that is fair enough. Then we moved on to the second rule, which talks about the fact that consideration must move from the promisee to the promisor. Now, it is very, very important that every consideration must come from the promisee. The promisee happens to be the person to whom the promise has been made to. And it is that person who is supposed to do something which is worth something for the agreement to be valid. I told Yvonne to wash my car for me. Yvonne washed my car for me. Yvonne, in this case, is the promisee. I am the promisor. Yvonne is the promisee. So Yvonne washed my car for me. Consideration has moved from Yvonne to me. So in this case, the consideration that came from Yvonne to me is a good consideration. It's a good consideration because it came from Yvonne to me. By Yvonne washing my car, the consideration moved from her to me. And it is a good consideration. That is the second rule. The third rule is also talking about the fact that it's also looking at existing public duty. Now, listen to this one carefully. This time I'm not dozing off, so whatever I say is fine. I hope you are comfortably laughing at your end. It's not easy. Okay. Now, when we talk about existing public duty as a rule, we are referring to the fact that when there is an agreement between two parties, we have already seen the fact that the consideration must move from the promisee to the promisor. Now, the promisee who should give the consideration, if he happens to have an existing public duty that commands him to perform that same thing that under the agreement between the two of us happens to be the consideration which will come from him, then we are saying that it is not a good consideration or it is not sufficient. If you look at the case of Collins versus Godfrey, what happened was that Godfrey committed a murder and he was supposed to be hanged. Okay, let me see. Okay, let me see if that is no. All right, that is not the case. But then this one, Godfrey made a promise to Collins that Collins should attend court and then give evidence on his behalf. Unknowing to Godfrey, the court had already invited Collins. It was actually a subpoena that the court sent to Collins to give a testimony on the same matter that Godfrey contracted Collins to come and give evidence on. So on the day Collins went to give the evidence, Godfrey didn't know that he had been contracted, but then he found out during the day that he gave the evidence in court that he had even been subpoenaed by the court. And when Godfrey heard this, Godfrey said that he was not going to pay Collins anything because he was even invited to come and testify anyway. So he doesn't think it is wise enough to pay him. Then Collins became very angry and then sent the matter to court. Now the court held that Collins was under a legal duty to attend court. He had not provided any consideration by going to court in the name of testifying for Godfrey. The court said that testimony he gave in court cannot amount to a sufficient consideration because he was under a public duty to give that evidence. Whether he liked it or not, he was supposed